1113 DM. Both parties are present along with counsel, Ms. Van Tol on behalf of the plaintiff, Ms. Drake on behalf of the defendant. We are here on the plaintiff's motion for a temporary order. Ms. Van Tol.
Thank you, Your Honor. I understand the court reads through the pleadings, so I will try to stick this to more of a response to what I received from Miss Drake. Your Honor, I don't really want to get stuck in the weeds here, but I do want to address a couple things. First of all, my client was a caregiver for this child. I have several text messages I could provide to this court related to that. My client provided sole care for this child in February of 2025 that I can prove via text message. Again, these allegations made by Miss Jackson are not accurate. I don't want to call her a liar. My client has been very, very, very clear with me. He wants to take a Christian approach to this case as much as he can. But some of the things are just not accurate, including that my client wasn't picking up this child. I have several text messages between him and the daycare provider with him telling her that he's on their way to pick the child up. This was all the way through April of 2025, as I alleged. With respect to this child, Your Honor, and concerns related to my client's care, there was a concern that my client was sleeping with this child when she was an infant. There were 4 pictures that my client was sent by or taken with my client's phone by Miss Jackson during the marriage. Not one of those pictures that I have show that the child had a blanket on her head. I would also indicate that with regard to the distracted driving, when it became an issue, my client downloaded Life 360, gave her the information to prove that he wasn't distracted driving. My client still has that on his phone. The only time that he touches his phone at this point is to accept a meeting, to play through his speakers if he has to take one for work while he's driving, to change a chapter of the scripture that he listens to on the way to work, and that's just to hit play, or to accept a Lyft rider. So those would be the only things that the court would ever see on there. With regard to his caretaking, again, there was nothing else other than those issues. I think at the end of the day, the way that this went down, my client has essentially been supervised, not completely supervised, but someone else has been present for his parenting time since May. It's completely inappropriate to continue that now. I understand that Miss Jackson is going to lose a little bit of control here. That's my client just wants to have a more consistent parenting time with his daughter to the extent that he's allowed to care for her. He wants to develop that relationship that he's entitled to have. I want to, again, point the court to the letter that was provided by the parties' mentor couple, the Christian couple. They have no concerns about my client's parenting that they've witnessed. There's not been a concern raised by anybody in her family about his caretaking of this child since May of 2025 at all. And my client has worked very, very diligently to address any concern that Miss Jackson had since that time. If we had started this case in May, my client certainly wouldn't be supervised moving forward. I mean, he would have completed what he would have been required to do in this hearing, as part of a court order. And I think we should move forward. With regard to the other issues that I put in my pleading because I knew that Miss Jackson would raise them, I think it needs to be clearly stated she had never, ever, ever, ever indicated to my client that she felt that she was forced to have sex with him until May of 2025. And she said she was forced to have sex with him on their 3rd date in 2021. That's a long time. That was after she told him that she understood that he had a emotional relationship with somebody for 3 weeks while he was in St. Louis. She disclosed that in February of 2025. She did not report anything to my client regarding this forced sex until May of 2025 before they separated.
Buckle up, guys. Today we are stepping straight into a courtroom where the tone is calm, but the stakes are anything but. Right from the opening, the father's attorney wastes no time pushing back against serious claims, painting a picture of a hands-on, involved parent. He leans heavily on text messages and documented interactions to show consistency and responsibility. What stands out is the controlled delivery, carefully avoiding direct attacks while still challenging credibility. This isn't just a defense, it's a calculated attempt to reshape the narrative before it even settles.
With respect to the alleged physical and sexual abuse, there are witnesses to these conversations, Your Honor, but Ms. Jackson has clearly stated that my client has never been physically abusive to her in anger, ever. What she has only alleged is that he was rough with her during sexual intercourse. And I know this is very intimate details of a relationship, but I think it's important to know. Leading up to their sexual relationship, Your Honor, my client was very clear with Ms. Jackson about preferences. He explained that to her before they had sex. He asked her to be open with him about what her preferences were. And again, nothing was indicated to him during this relationship until after she found out about this phone call situation that he had with another woman while he was in St. Louis in 2023. So the concern we have ultimately, Your Honor, is sort of this revisionist history. My client has always accepted her perception of things. He did not want to downplay how she said she felt. So he has done the best he can in a Christian way to accept her version of events, how she stated them. What I can tell the court is that my client has several ex-sexual partners who would be able to testify as to exactly how he approached these conversations in the past. And everybody's been open with him about what they want, what they don't want. And so it's very difficult for somebody in hindsight to change something when they didn't know it was a problem. So I think that's the biggest issue here. I would also like to note that this allegation that there's somehow a prosecutor review of a complaint made by Ms. Jackson, my client was not even contacted by the police until after he signed the documents at my office. After he told her, I can't keep doing this. I'm going to have to talk to an attorney. That's when she made the report. And again, it's our understanding that the report was from 2021. So I'm not exactly sure how that's going to play out, but ultimately, this is not a case where my client has been physically abusive, that he's been controlling. None of that is reality. My client has voluntarily done every single thing she's asked him to do. He's never asserted control over her. This is an unfortunate case in which he wouldn't say it, but I'm going to say it, that I think that we're trying to use perceptions of past behavior to gain an advantage in a custody and parenting time case.
All right, guys, now things start to get intense as the argument shifts from routine parenting into deeply personal and uncomfortable territory. The defense begins addressing allegations that go far beyond custody, including claims tied to past intimacy and behavior. The strategy here is clear: reframe everything as misinterpretation or hindsight distortion. By calling it revisionist history, the attorney is essentially accusing the other side of rewriting events to gain leverage. This moment hits hard because it blends emotion, logic, and controversy all at once, pulling the courtroom into a much heavier atmosphere.
I think it's appropriate. These parties agree regarding their kid in terms of what happens in doctor's appointments, who she sees, following medical advice, where she goes to school. This request for sole legal custody doesn't make sense. She has controlled and dictated everything. Everything. So it is just not a case where I think there's some sort of ability for my client to coerce her. I'm going to ask that the court award joint legal custody on a temporary basis, allow the front of the court to do their job and review the issues before the court, and that the parenting time be unsupervised. Again, my client has been essentially supervised since May of 2025. No issues have happened since that time. He would like to have individual time with his child, Tuesdays and Thursdays and every other weekend. And if the court's going to want to do this in a slower fashion, Tuesdays and Thursdays and one overnight on a weekend to start every other weekend is fine. But my client stands by his pleadings. He can prove his pleadings, and we're asking that the court enter an order consistent with what he requested. Thank you.
Thank you. Ms. Drake.
Thank you, Your Honor. I find it very concerning, the downplaying of my client's experiences. She filed a report in August of 2025. It's not her fault that it took this long for the investigation to move forward, and he wasn't contacted as soon as she filed her complaint. But to make an allegation that she waited until finding out that he was going to file for divorce to report the abuse she experienced is just absolutely horrendous. I think there is a difference in perception here, because my client's experience during the marriage is very different than what Ms. Van Tol just described. There were a lot of unilateral decisions made. She does feel like there's coercion in the relationship, and she stands by her claims. I apologize for the train. She does stand by her
Not in your control.
Just, it should go by quickly. That she, I lost my train of thought.
I'm
no
sorry.
pun intended. That's all right. She experienced this abuse. She feels like she was pushed for some decisions, but she stood by her belief that the child was not safe in Mr. Jackson's care alone, which she limited his alone contact with him since November of 2024. And then his parenting time has been limited to about 4 hours on average per week by his own design. She's been flexible. She's offered more time. He picked her family members to be supervisors. She didn't force that. She just wants to create a safe environment for the minor child. The minor child is starting to be more vocal, developing language skills so she can speak up for herself. But the fact that she came home on 3 different occasions and the child was in front of a space heater, and the last time was hard to awaken and was very lethargic, caused my client great concern. The Life 360 app with the driving, she noticed that there were still indications that he's distracted by his phone and that he has a tendency to speed and drive erratically. So there are concerns. And once she discovered that pattern, she stopped allowing the driving to occur. She took on the responsibility of the majority of that. So there are concerns. She's not denying that he has a good relationship with the minor child. She wants that. Her and her family have been supporting that, which is why they've been willing to be there for parenting time, why she's been willing to meet him and accommodate other requests. I think to jump to 2 evenings a week and alternating weekends would be a huge change for this child. She's been exercising this parenting time for 8 months with dad about 4 hours a week. I could see potentially moving to some unsupervised time, but overnights, I think that we're too ahead of ourselves when he hasn't had alone time with the minor child for at least 8 months, if not more. But his parenting time, again, has been limited to 4 hours per week by his own design. We would like to move forward in a positive manner, but the reality of things is there has been coercion and abuse in this relationship, which causes my client concern if the parties were to disagree on a legal custody matter, that she may be pushed to agree to Mr. Jackson's perspectives. And so that is why we were asking for at least temporary sole legal custody in this case. We are asking that the parenting time remain on 2 evenings a week and then maybe some daytime on a weekend, but we do not want overnights at this point. We would love for the front of the court to do more of a deep dive into that so that we can assure that the minor child has stable and safe parenting time with both parties. My client has also been accommodating some FaceTime parenting time at the request of Mr. Jackson. She'd be willing to continue that a couple times a week as well. please note that she is not trying to prevent him from establishing a relationship with the minor child. She's simply trying to ensure the safety based on the behavior she observed firsthand between Mr. Jackson and the minor child. So we are asking the court to take those things into consideration when making its decision as it relates to a temporary order. Thank you.
All right, guys, this is where the defense reaches its peak, laying out a full narrative that ties everything together. The attorney suggests that these allegations aren't just disagreements, they're tactical moves in a custody battle. He emphasizes cooperation, shared decisions, and the absence of control, trying to dismantle the idea of coercion entirely. There's a strong push for joint custody and unsupervised parenting, signaling confidence in their position. This segment feels like a closing pitch before the storm, where every point is sharpened to leave a lasting impression on the judge.
Thank you.
Your Honor, if I
Ms.
can
Ventol?
just briefly, Your Honor, again, the statements made in the response, again, I can prove. I have the letter from the couple that they both talked to, that my client's been counseling with. They're indicating that they don't see concerns. I'm not exactly sure how my client, again, has been coercive, even just based on what she's saying. She has dictated everything since they separated, and my client has done nothing but bend over backwards to accommodate. He chose her family because that's who she was comfortable with. He chose church people because that's who she was comfortable with. He's done everything to accommodate her. He hasn't questioned her. If you look at their text messages, there's nothing in there that's abusive or threatening. I have them. There's I love yous all the way through April between the both of them. It's just really sad. I don't see any reason that these people who have gotten along just fine without court intervention shouldn't have joint legal custody now. Thank you.
All right. Thank you. Given the severity of the allegations, particularly the reported criminal matter that's before the prosecutor, the minor child's age, the current supervised arrangement that's been in place, for quite some time, and the need for a full investigation by the front of the court, I'm going to order on a temporary basis that mother have sole legal custody on a temporary basis. And again, this is only so that the court has a chance, and the front of the court has an opportunity to sort all of this out. The prosecutor's investigation can be completed. Because generally the court does default to joint legal custody and would not, on a temporary basis, do this. But given all of those things I just mentioned, I think the court's primary goal here is to protect this minor child, and also to limit contact between the parties until the investigation by the prosecutor is completed. So again, this is simply a temporary order that can be changed and at any time, and particularly when the court makes a final decision on this case. But it is also clear to the court that parenting time should be expanded, given the admission that that the father has a very close relationship with his child. But the reality is he has had very limited parenting time for quite some time. So I think this should be transitioned carefully and slowly. And so the court will order parenting time every Saturday from 10 a.m. to 5 p.m. And one weekday evening per week from 5 to 7:30. We will have a neutral third-party supervisor present for those times for at least the first 6 weeks. And then assuming that all that goes well, then we can move to unsupervised parenting time. And again, this is simply pending the front of the court's investigation and recommendation. And again, this is for all the same reasons that I mentioned regarding legal custody. I will refer this to the front of the court on the issues of custody, parenting time, and child support, with the parties splitting that fee. And let's see, was there anything else? I'll issue a status quo financial order.
Buckle up, because the energy completely shifts as the opposing attorney steps in and pushes back with force. This isn't just disagreement, it's a direct challenge to everything that was just said. The tone becomes more emotional, more urgent, as claims of abuse, coercion, and safety concerns take center stage. Specific incidents are brought up, including troubling situations involving the child, which instantly raise the stakes. The argument here focuses on protection, not control, making it clear that from this perspective, caution isn't optional, it's necessary.
Which also there's a joint account. Is that correct?
Yes, the parties
Okay.
have been using the joint account to pay expenses.
All right. And clearly there'll be an accounting as to how those deposits and expenses are going. Is there anything else?
Your Honor, with regard to the parenting time, if my client is unable to find somebody available Saturdays from 10 to 5, can we adjust that in some way so that he's able to get his time? He's been doing 2 weekdays and some weekend time now, and the court's reduced it now to 1 weekday and 1 weekend.
My intent was not to reduce. So if I've done that, that's not what my intent was. My intent was to actually minimally expand it. So, but I also understand the need for some flexibility because you have supervisors.
Yeah, so he had been doing 2 weekday evenings and some weekend time when it was allowed by Miss Jackson. So we would request if we can get the 2 weekday evenings. I know he can get supervision for those. He has in the past. Miss Jackson has been supervising also. She, again, I think just this week they went to the mall and he was hanging out with their child and she was shopping. But with regard to Saturdays, if we can do the 2 weekdays and we can try to find somebody on Saturday. If we can't, if we can do Sunday, after church or something. I mean, they do have church families that are, my client's very close with the church. And
May I
people there.
confer with my client briefly, Your Honor, and then
Sure.
I can get some suggestion.
Okay. I'm going to take us off the record while we wait.
Yeah, that's fine. Thank you.
Oh, I just took us off the record, Ms. Drake. So
Sorry.
that's all right. We'll start it back up again, Ms. Van Oler. All right, Ms. Drake.
My client doesn't have any objection to continuing the 2 evenings per week to keep consistency for the child, and then she can be flexible with regard to the weekend time, whether it be a Saturday or Sunday for a couple hours to facilitate that. She'd prefer not to be the supervisor, so she was happy to hear the third party, but she will help facilitate as much as she can because, again, she's not trying to prevent him from seeing the child. She just wants to make sure that everyone is safe and it's consistent. So we can be flexible with that. However, we need to put it in the order.
Okay. Well, I think again, the court's intent was to have more extended amount of time on the weekend. So, whether it's 10 to 5 or 9 to 4 or 8 to 3 or whatever will work out either Saturday or Sunday. That's what I'm ordering, but I appreciate the flexibility.
All right. So 2 weekday evenings, 5 to 7:30, just so I can draft the order. Saturday or Sunday, flexible times for 7 hours, and the parties are going to work together to find third parties to get the supervision going. Right.
Right.
That's how we're handling it. Okay.
Yes.
And then after 6 weeks, as long as everything's good, it's unsupervised.
Correct.
Okay.
Pending the front of the court recommendation.
And pending the front of the court. Yeah, but so I'm trying to understand, does my client have to wait for unsupervised parenting time for the front of the court recommendation, or is he going to get unsupervised?
After 6 weeks. It's just,
Okay.
I'm just saying that it will stay that way until we get that front of the court report and recommendation.
Okay. Got it.
Okay.
Thank you, Your Honor.
All right, guys, this is the moment everything builds toward the judge's decision. After hearing both sides, the court cuts through the noise and focuses on one thing: risk versus certainty. Despite the defense's push, the judge leans toward caution, granting temporary sole custody to the mother. At the same time, there's recognition that the father should remain involved, but only through a structured, supervised path forward. It's a balanced but firm ruling, showing that in situations like this, the court would rather move slowly and safely than take chances.